We pour so much of our lives, our energy, our time into our jobs. But if you've ever really stopped and wondered, just how secure is my job really? So in this explainer, we're going to break down the essential rules of job security here in the Philippines. And trust me, this is stuff every single employee should know.
So let's just imagine this for a second. You're having a rough day, you're swamped, and you make a mistake. A single, honest-to-goodness mistake. Can your boss just walk up to you and say, "You're fired," right there on the spot? The answer, well, it might not be what you think, and it tells you a whole lot about your rights. It all boils down to this really powerful legal idea called security of tenure. And let's be super clear about this. This isn't some nice-to-have company policy. No, this is a right that's literally written into the Philippine Constitution. It's basically a legal shield that says a regular employee can't just be fired for no good reason or without a fair process. Okay, now this is where things get really fascinating. The law actually looks at your job as a property right. Think about that. That's a huge deal. It means your employment isn't just a role. It's legally considered an asset, kind of like your house or your car. And just like any other property, it cannot be taken away from you without following very strict, fair rules. So, if your job is a property right, how can it be legally taken away? It's not impossible, of course, but the law is very specific. There are only two legitimate paths an employer can take to terminate your employment, so let's walk through them. The best way to think about it is like a fork in the road. One path is called just cause, and that's all about something the employee did wrong. The other path is authorized cause, which has nothing to do with the employee and everything to do with the company's situation. Let's head down that first path, the just cause path. All right, we're on path number 1, fired for cause. Now, this is the one that probably comes to mind when you hear about someone getting fired. It's all about situations where the dismissal is a direct result of something the employee did or maybe didn't do. The law actually gives us a handy list of valid reasons for a just cause termination. And to make it a little easier to remember, you can just think of the acronym SGFWA. This covers things from serious misconduct to fraud, all the way to willful disobedience. But I want to zoom in on one of the most common and honestly most misunderstood reasons, gross and habitual neglect. So what in the world is gross and habitual neglect? The key thing to get here is that the bar is set really high. Gross neglect isn't just making a mistake. It's showing a total conscious indifference, like a real I don't care attitude. And then there's the word habitual. That means it has to be a pattern of behavior, not just a one-time slip-up. And this brings us right back to our first question, doesn't it? If neglect has to be habitual, does that mean you can never, ever be fired for just one mistake? Well, like with many things in law, there's a very important exception to the rule. Let's look at a real-life court case to see what I mean. An employee messed up with inventory management, but, and this is the crucial part, they tried to fix it. They followed up, they showed they were trying. The Supreme Court looked at this and basically said this wasn't a thoughtless disregard of their duty. The big takeaway here, your effort matters. A mistake you try to fix is not the same as gross neglect. Okay, now let's flip the script completely. A delivery driver leaves his motorcycle unlocked for just a few minutes, and it gets stolen. In this situation, the court said that this single act of neglect was enough to fire him. So why the different result? Because it was such an obviously careless mistake, and it led to a huge financial loss for the company. It's a powerful reminder that the consequences of your mistakes really do matter. All right, let's back up and take that other path at the fork in the road. Authorized causes. This is a completely different world. In this scenario, you could be the best employee of the month every month, but you're still being let go. Why? For reasons that have absolutely nothing to do with your performance and everything to do with the business itself.
And hey, just like with just cause, there's another handy acronym to remember the main authorized causes, RRCD. This covers things like redundancy, when a position is no longer needed, all the way to the complete closure of a business. Let's take a closer look at a really common one, retrenching. So, a company is losing money and says it needs to downsize. Can they just start letting people go? Oh, absolutely not. The law has some very, very strict rules. The company has to prove, and I mean prove, with audited financial statements, that the losses are real and serious. They have to use a fair system to decide who goes, and maybe most important of all, it has to be a total last resort, not their first move. You want a perfect example of what the law calls bad faith? Here it is. A company lays off an employee, claiming their job is redundant, no longer needed. A few weeks later, they post a job opening online for the exact same position. I mean, come on. The court saw right through it. It was just a flimsy excuse to get rid of someone. A classic illegal dismissal in disguise.
Okay, so we've walked down the two main paths for letting someone go, just cause and authorized cause. But here's the thing. It doesn't matter which path you're on. There is a set of rules, a process that must always be followed. When it comes to termination, the how is every bit as important as the why.
All right, here is a number that every single employee should know by heart. 6. An employer can put you on what's called floating status, basically a temporary layoff, for up to 6 months. But if 6 months and 1 day go by and they haven't called you back to work, that automatically becomes constructive dismissal. It's a fancy legal term that means even if they haven't officially fired you, their actions have made it impossible for you to work. It's a firing in all but name. And this brings us to what is maybe the most important rule in this entire process, the 2-notice rule. This is the bedrock of a fair termination. First, you have to get a written notice that explains exactly why they're thinking of letting you go. And this is so important. It has to give you a real, genuine chance to explain your side of the story. Second, only after they've considered your explanation, the company has to give you a final, written notice of their decision. This isn't just a suggestion, it's your fundamental right to be heard.
So, what happens when a company gets it wrong? What if they don't have a good reason? Or maybe they just completely mess up the process we just talked about? Well, the consequences for them can be really severe. If a court rules that you were illegally dismissed, the law provides some pretty powerful remedies. The main goal is to put you back where you were before you were wrongfully terminated. This can mean getting your old job back, getting paid all the salary you lost while you were out, and in some cases, even getting paid extra for damages. Now, check out this fascinating twist. What happens if the company had a totally valid reason to fire you, but they messed up the process? They forgot one of the notices, or they didn't give you a real chance to explain. The law says the dismissal still stand, but the company has to pay a penalty for violating your rights. It's the court sending a clear message. Getting the why right isn't good enough. You have to get the how right, too. Phew, we have covered a lot of ground today. The 2 paths to termination, the absolute must-follow procedures, and the serious consequences of breaking the rules. You know, the law really tries to strike a balance, protecting an employee's right to their job while giving businesses the room they need to operate. But here's the final question. In the real world, out there in our actual workplaces, do these rules create a truly level playing field? That's something worth thinking about.